So my Supreme Court case is Mapp versus Ohio, and it deals with the Fourth Amendment right that protects against unreasonable searches and seizures. So the question being asked in this case is whether evidence discovered during a search and seizure conducted in violation of the Fourth Amendment of the Constitution shall be admissible in a state court. And the answer is no. The sides for this case, the petitioner is Mapp, who's in the picture, and the respondent is the state of Ohio. So the background began on May 3rd, 1957 in Cleveland, Ohio, when 3 police officers arrived at Mapp's house in pursuit of a bombing suspect and evidence. So after calling her attorney, Mapp refused to let them in without a search warrant, so the officers returned 3 hours later with what they said was a search warrant. And so Mapp asked to see the search warrant, and after taking it, they struggled to get it back and placed her under arrest for being belligerent. Then they continued to search her house, and they found obscene materials in a trunk in her basement, but they never found any bomb-making materials. So she was convicted for possessing obscene materials because they were illegal in Ohio at the time. So the Ohio Supreme Court upheld the conviction even though they said that the evidence was unlawful because they didn't have a real search warrant. They said that the evidence could be used against her because of the rulings in the 1949 case Wolf versus Colorado. So the ruling in that case said the exclusionary rule did not apply in state court proceedings, and the exclusionary rule says that evidence illegally seized in violation of a suspect's rights cannot be used against them in a criminal prosecution. So then Mapp appealed to the Supreme Court, saying that her First Amendment right to freedom of thought and expression was violated because she was not allowed to own obscene materials. And then the American Civil Liberties Union filed an amicus brief for the reconsideration of the Wolf case. So they argued on March 29, 1961, and it was decided June 19, 1961. And they ruled that the exclusionary rule applies to evidence found in violation of the Fourth Amendment in all state proceedings. The significance is that state police and state courts now had to follow the Fourth Amendment right against unreasonable search and seizure, and illegally obtained evidence couldn't be used against a defendant. So it reversed the decision that was made in the Wolf versus Colorado case. So a related case is Elkins versus United States. And in this case, police in Portland, Oregon, seized evidence of illegal wiretapping from the house of James Butler Elkins on an unrelated search warrant, and he was convicted in federal court, and then he appealed on the basis that the evidence should have been admissible. So the Supreme Court ruled that evidence illegally seized by state or local officers could not be used in federal prosecutions no matter how relevant it was. And then another case is Schmerber versus California. And Schmerber was convicted of a DWI based on a chemical analysis of his blood that was taken after an accident. And the sample was taken at the instructions of officers, and it was taken against his will. He appealed to the Supreme Court, saying that this denied him his right to self-incrimination, but the court ruled that this did not mean that he had been compelled to be a witness against himself, and that obligation that makes a suspect the source of real evidence does not violate his right.
All right. Great.